May I please, your lordship? The name of Mr. B.J. Mukherjee is not reflected in the cause list.
In the same matter, item 6.
Yes.
Registry to reflect the name of Mr. B.K. Mukherjee.
J. Mukherjee.
B.J. Mukherjee as counsel for the respondents in the further.
May I pay for listing of a criminal appeal for orders?
When?
Next week, any deadline? Publish.
Madam, my lord, yesterday in supplementary item number 16, my lord, hearing was taken place. And I may be allowed to submit some judgment before the lordship. Okay. Keep looking.
Though I've already passed I've already dictated 99.9% of the order. Will allow it.
May I please, your lordship? I beg to mention item number 25 of the daily list, lordship.
25.
25. Lordship, Mr. Kial is out of station.
Why is he out of station when these type of cases come? Right. On the prayer for adjournment made on behalf of Mr. S. Ken, Leonard Standing Council for the Assembly. This is the matter after?
After lordship, 2 weeks. Much obliged.
May I please, your lordship? Lordship, I beg to mention for listing of one criminal appeal, 73 of 23. It was last posted on 20/11/2024.
When do you want?
Lordship, any date, lordship, next week.
Next week, decide if
And Friday, lordship,
after that.
1st September. Deeply applied.
May I please, your lordship? I beg to mention item number 15, my lord. So, my lord, my senior, who is also the conducting counsel in this matter, is currently out of station.
For adjournment made by Miss.
Item number 15.
No, your name.
My name is Nikoli, sir. Nikoli Jijimo.
Huh?
And my item number 15. Yes. Yours is 14. Yours is 14.
I am appearing for the 14, madam.
They have submitted a slip, adjournment slip yesterday.
The my matter is different. They are for the only, it's for the bail matter.
Huh?
It's not for the final hearing.
Who?
My matter, madam.
Your matter.
That may be taken up, madam. Because last occasion also, they have taken the time without our consent, madam.
You see, because they submitted a list, I didn't even read.
Because the, our part is different, madam. It's only for the bail purpose, madam. On the last occasion also, without informing us, madam, they have taken the adjournment, madam.
Both of you are accused. Both of you are convicts.
Yes, we are convict, madam. We have filed for the bail application, madam. The last occasion also, it was listed for the bail method. But the, without informing us, they have taken the adjournment, madam.
See, the problem is, once we get the adjournment slip, then we usually say, okay, since they have asked for adjournment, we don't usually read.
Their matter may be adjourned, madam. I have no objection, madam. But my matter may be hard, madam. Mine is item number 14.
Yeah, yes, we are in jail.
Yes, we are all in jail, madam, for last nearly 8 months, madam.
We'll list it next week. Either we have to hear all, otherwise it becomes a problem. Hearing partly.
All the times they are taking the adjournment. That's the problem, madam. The last occasion, without informing us, they have taken the adjournment, madam. And my clients are in the inside jail, madam. I am answerable to the client what has happened, madam. And they have not informed us also. Yesterday also.
Why have you not informed the other side? The other case should inform. It's a that matter.
My lord, I am talking about item number 15 and their item number 14.
13 and 15 are joined together.
Okay, okay.
First, courtesy
He is in
note
14.
My lord,
14, you are in 15.
since my senior is already submitted the letter of absence, please kindly pass over the matter only for today. S.H. Sigdar.
That's a seat there is nowhere, not in the this point.
Sigdar is there. Sigdar is there.
My lord, only for today, please.
His name is there in item.
Name is there.
A. Chaudhary, P.K. Das.
We'll give you last opportunity, no more adjournment.
My lord, next month, next week.
Yes, next week.
Thank you so much, much observed.
I know. On the prayer made for, the prayer for adjournment made on behalf of Mr. S.H. Sigda, Learned Counsel for the appellant in criminal 419 of 2024. List the matter on. List the matter on first September. No further adjournment will be given to the learned counsel for the appellant in criminal 419 of 2024.
Here, my lord, I am filing the affidavit today. Maybe taken after the affidavit. One second.
Yes.
Yes, madam.
What is this basically?
Madam, matter relates to interpretation. My lord, in fact, this is second time. My lord, the question is, my lord, whether they can charge levy tax on the VAT element also. Okay. So this is the main issue. The issue is very small, my lord, only it needs interpretation. Your Honor.
Whether they can be taxed on the.
On VAT element also, because in our product, VAT element is also there. They are calculating on that basis.
Tax on the.
On the VAT also, madam.
Okay. Mr. B. Gogoi, Learned Counsel for the
Finance taxation department.
Finance and Taxation Department.
Okay, fine.
Submit that affidavit will be filed
Yeah.
within the course of the day. List the matter when?
By any day next week in that.
After 2nd of, my lord, September one.
List the matter on,
By on 4th.
1/4,
okay, for,
Alright.
deeply all right.
I don't know why is it, why is it here? It should be before DB one, why is it here?
It was before, earlier it was before DB one.
Probably just,
Wrongly, my lord, it's come up.
probably yes, sent it. Yes. What number one has sent it here?
Oh, yes, might be something.
Anyway, let it be, man. You get chance enough to learn.
May I please, your lordship? Appeal against the order of principal just family court. My lord,
7 lakhs,
7 lakhs, my lord.
7 lakh.
My lord, he is a daily labor, my lord. And my lord, the daily labor and judgment was passed, my lord, without perusing the assets and liability of the petitioner, my lord. Only the this appellant assets and liability was directed to submit. No assets and liability was directed to submit.
You deposit 50%,
My lord, that is very high, my lord.
you deposit 50%.
But 20%, my lord.
Oh.
My lord, he is a daily labor, my lord. It is not possible.
Sorry.
May I please, lordship?
Miss Nazia Hassan,
Yes, lordship.
the appellant, submits that the interim judgment is 21 to 25. Part 5. The court of the addiction section that comes special judge of Morigaon in POCSO case number 43 of 2024. Arising out of Mayong PS case number 155 of 2023. By which the appellant has been convicted under section 6 of the POCSO Act. Should be set. Issue notice returnable. Admit the appeal because of the issue. Issue notice returnable in. Which Ms. A. Begum, additional PP, appears. the appellant is to submit a soft copy of the fee with the office of the which shall thereafter communicate same to the OC of the concerned police station for service of notice upon the respondent number. This is the matter of the police.
There is a interlocutory obligation.
Miss, in the, I write, Miss A. Begum, additional PP, is granted 5 weeks time to file written objection to the application under section 430. PNF. This is the matter to file. The other one also, right? And returnable, notice returnable in 5 weeks.
Obliged, Lordship.
No one applies for the affidavit. This is the matter.
I'm sorry, I could not prepare on time. Was in item 8, let's.
Item eight,
Legal matters.
give me item eight. Mr. Bitu Halda.
Yes, let's.
Yes, the appellant submits that the judgment dated 9/10/2024 passed by the special judge Foxo in Sukhya in Foxo case number 51 of 2022 arising out of Bordumsa PS case number 13 of 2019, by which the appellant has been convicted under section 6 of the Foxo Act. Is convicted and sentenced under section 6 of the Foxo Act, should be satisfied. Admit the appeal, call for the PCR, which notice returnable in 5 weeks. This A. Begum, additional appears for the state. Appellant to take, to submit a soft copy of the appeal to the office of the PP, who shall forward the same to the OC of the concerned police station to serve notice upon the respondent. This is the matter of 5 weeks. Then in the
We filed one IA for suspension of sentence, but that has not been numbered, let's.
the same, Ms. A. Begum is granted 5 weeks time to file it.
It has not been numbered yet, let's.
Oh,
Registry is to number the IA.
oh,
Serial number is there only, I think.
this is it. The IA. But in the main case, you write, registry to register the IA.
Filed under section 430 of the.
File under 430 BNS, unless the same.
After admitting the
As fixed for.
After filing. Item 9 is the same actually.
same.
It has not been, no filing number has been there. Filing number of, should have been given.
I represent 5
Take a look at it. Should have been numbered, that's it, but generally it has been
Generally numbered.
generally numbered, let's say.
Anyway, it doesn't matter. Like, item 10 no. Item 11. Same, none appears after the week. Oh, wait, is it a jail appeal? Item 10 a jail appeal. That's 10, I mean 10, that's not 9. 10 and 11, I think jail appeal. A jail appeal. Okay, right. Right? Doesn't appear to be a jail appeal. It's supposed to be. Jail. Oh, it's done very well. Right. The jail appeal against the judgment dated P9/24 passed by the court of the special judge Foxo, Golaghat, in special Foxo case number 54/2021 arising out of Mera Pani PS case number 93 of 2020, by which the appellant has been convicted section 6 of the Foxo.
Ensure.
This is a legally problem. Okay, what is right? Huh? I will. Uh, admit the big call for the PPS. If you notice to the if you notice returnable in for 5 weeks, 4 weeks or 5 weeks, miss a exam, except PP except notice from that. Then we have noticed that one Miss Nirmala Chowdhury, advocate, has been engaged as a legal aid counsel for the appellant. However, the name of Miss Nirmala Chowdhury has not been reflected in the call. But it is stated to reflect the name of Miss Nirmala Chowdhury, legal aid counsel in the call. Registry to provide a soft copy of the appeal to the office of the PP. Who shall thereafter communicate the same to the OC of the concerned police station for serving notice upon the respondent number 2. List the matter of the file. Items 10, 11. 11. Out here. Here. This is again appeal against the judgment dated 7/1/25. Passed by the court of the additional session that comes speculated that Pokso Kamrup and Kamagwati in sections special case number 229 of 2020 arising out of Bara Lumuk PS case number 101/20 by which the appellant has been convicted under section 6 of the Pokso. Then after everything will be the same except for the advocate's name is Begum Roshan Ara Sultana. Okay, 336, the name is that. Well,
Please, Your Worship. This appeal against judgment order dated 36/25 time.
date of the day. What is
D.
the date?
Boramal.
Huh?
D. Boramal.
But Mr. D. Bora, no, counsel for the appellant, who submits that the judgment dated 36/2025 passed by the section judge Kamrup Mingao in section case number 295/2014 arising out of Palash Pari PS case number 74 of 2011, by which the appellant has been convicted and 302 IPC to be said effect. Ms. A. Begum, editor PP, accept notice on behalf of the state. Admit the appeal of the PCR. This is the matter after court.
There is an I minor for suspension of sentence.
Just right in the I, right? Ms. A. Begum, editor PP, you granted 4 weeks time, 5 weeks time. To file written objection to the application made under section 430 PN. The matter of file.
God bless you.
The only one. So book is to be made.
No, here in this case, I am appearing for the informant, copies of the records will not furnished to me. There is a direction by order dated 17/2/2025 in the executive application.
I will submit today, during course of the day.
You serve what?
My lord, copy of the IA as well as the appeal, my lord. There is a direction, my lord.
Is the paper book necessary?
Yes.
Huh?
Yes, my lord, before that, my lord,
Huh?
there is IA pending, my lord. There is.
Hear it. You want, you serve him a copy.
Plus, you know, plus. I will stop during course of the levels.
Mr.
D Google.
He over. Then counsel for the appellant submits that he will serve a copy of the IA
IA as well as the, my lord, criminal appeal.
as well as the criminal appeal to Mr.
Yeah.
A. Amit, Learned counsel for the informant.
Yes.
This is the matter. When?
Lord, may I pay for next week? Next Tuesday, Lord, if possible. Almost, my lord, 2 years behind our bar, Lord.
Okay, this is the matter.
Deeply blessed.
They submit that the paper book will not be necessary for disposal of the IA.
Deeply blessed.
16.
Please, Your Lordship. The delay has been thrown in this matter, Lordship.
Yes.
Now it has come for the order stage,
Yes.
and their name has not been reflected in the copies.
My lord,
Name.
file my wakalatnama. My name, my lord, is not being listed in the copies.
You want adjournment?
Yes, my lord, they have signature. In fact, my lord, I have not been served with a copy of the name of appeal also.
Lordship,
For you not be served.
within the course of the day, I will submit the memo of the appeal, Lordship.
Mr.
K. Jain on behalf.
Jain, appearing on behalf of Mr. S. K. Submits that he will serve a copy of the memo of appeal to Mr. S. Mitra, Learned counsel for the respondent during the course of the day.
My lord,
During the course of the
Lordship.
day. Accordingly, this matter when?
after 2 weeks, my lord, I'll have to submit the submission of written submission.
Written, what is written objection or? what?
Objection.
Okay. This the matter on? Yeah, good. In the meantime, Mr. S. Mitra, let's find a written objection.
My lord, my name may kindly be reflected in the copy.
Registry to reflect the name of Mr. S. Mitra as counsel for the respondent in the public.
Obliged, my lord.
My submit.
My lord, so the matter has to go before the mediator, register the appeal, and this is the same. I is accordingly disposed.
Obliged.
There also no objection? Heard Mr. S. Vanik, Learned counsel for the article to submit that there is a delay of 3762 days in filing the appeal. This everyone, objection PT, submit that there is no objection to the delay being funded. Submit in the option of the party, the delay is condoned, registry to register the appeal, this is the same. I is accordingly.
Well, I'm standing in as a legal aid counsel.
Okay, Mr. S. Vanik, legal aid counsel, huh, this is-
Obliged.
Bill. Okay, I'm accepted. Right, Miss R. Begum, Learned counsel for the applicant to submit. There's a delay of 14 days in filing the appeal against the judgment and decree dated 22/05/25. Passed in XT bracket civil case number 622 of 2019 by the principal judge, family court number 1, Kamrup and Bhat. On considering the grounds of delay, we find that sufficient cause for the delay has been made out as reflected in para 5 of the application. According to the delay of 14 days from both, the registry to register the appeal and list the matter. the next week.
Last minute.
Please, your lordship.
Yes, madam. What is the graph for delay? What's your timing?
Lordship, no matter lordship, noticing will be issued.
Oh.
Condemnation of delay was
Right.
7 days.
You want notice to be issued?
Lordship.
Okay. Third means,
SR Major View.
huh?
SR Major View.
Yes, sir. Mother being the counsel for the applicant. Submit that there is a delay of 7 days in preferring the appeal against the impugned ex parte judgment and order date 10/4/25 and decreed 10/4/25 passed by the learned principal judge, family court, Qatar in FC bracket civil case number 370 of 2020. Issue notice returnable in 4 weeks. Applicant to take steps for service of notice upon the respondent by a registered post of AD within 3 days. This is the matter of liberty.
Lord, in this matter, 28 days delay, my lord, and ground I have stated in paragraph 4, to get the records at the and the preparation of this appeal to 28 days delay, my lord.
Third, Mr.
PK Decker.
Huh?
PK Decker.
PK data, land council for the applicant. To submit that there is a delay of 28 days in filing the appeal against the judgment and decree dated 27/2/25 passed by the learned principal judge, family court Qatar at Silchar in FC civil case number 409 of 2023. By which the prayer of the applicant appellant for a decree of dissolution of marriage was rejected. On considering the grounds of belief as provided in para 4 of the act, we find that sufficient cause for the delay according the delay of 28 days from the registry to directed to register the appeal unless the matter in the next.
Give floor, please.
Lordship is hearing.
Yes, yes, it's you, I've heard him. You got nothing more to say.
Lordship, I'll be referring to the judgment passed by the Honorable Court in criminal appeal 17 of 2016. Lordship. In Hawa Khatun versus Abdul Aziz matter. Yes.
Okay,
Which one is that? Hawa Khatun, Hawa Khatun. Parliamentary overseas.
In my appeal, my lord, memo, it's 41 probably.
no.
Not,
This is a paper book belonging to the Hawa Khatun, which
Okay.
has already been
Okay.
disposed of. Criminal appeal 17 of 2016.
Page 41.
41 of my appeal, my lord. Memo, not my appeal. No, memo, not my appeal. আমাকে দিয়ে না, আমি আবার কিছু করতে হবে।
Has your lordship got it?
Yes, yes.
Lordship.
Very much.
I take your lordship to para 8 of the judgment.
Alright, yes.
Yes. Without delving further into the evidence that had been rendered by the prosecution, we take a look into the deposition of DW2, based on whose evidence the learned additional session judge arrived at a conclusion that the victim was not in the house of the accused persons immediately before the occurrence. Then I will take your lordship to para 10. We specifically take note of that DW2 had tea with the deceased Almas from 8 to 8:30 p.m. up to 9 p.m. and thereafter both of them left each other, where DW2 went back to his boat. It is discernible from the evidence of DW2 that he and the deceased had parted around 9 p.m. Now again, when we look into the evidence of PW11, we find that around 10 o'clock in the night, the accused Jasmat, Mukhtar, and Ziaul came and called the deceased Almas by saying that he should accompany them. Accordingly, Almas went with the accused persons, but when he did not return home till late night, PW11 woke up and came outside and heard people speaking in the house of a neighbor, Abdul Aziz. The last scene theory of the accused Jasmat, Mukhtar, and Ziaul would therefore start at a time past 10 o'clock when they came and called Almas and took him away with them. The last seen together theory cannot be related to the evidence of DW2, which is specific that DW2 and the deceased Almas had tea between 8 to 8:30 p.m. and 9 p.m. and thereafter both of them parted the company of each other. In this background, the conclusion of the learned additional session judge in paragraph 52 of the judgment dated 28/9/15 is erroneous. So, Lordship, by that judgment, Honorable Court interfere with that part of the earlier judgment, whereby the accused persons were acquitted, my lord. The conclusion that the defense seemed to have discharged its burden by tendering the evidence of DW2 to show that the deceased victim was not in the house of the persons immediately before the occurrence is also incorrect and cannot be based on the evidence of DW2. In the circumstance, if we take into account the evidence of PW11, that the accused Jasmat, Mukhtar, and Ziaur came and called Almas and he accompanied them after past 10 o'clock in the night, we find it comes within the purview of last seen together theory. In the circumstances, it is for the said three accused persons to explain the situation as to what happened to the deceased Almas after he had accompanied them. Then para 11. We also take note of that the said piece of evidence of PW11 that three accused persons came and called the deceased Almas and he went with them past 10 o'clock in the night remains unconfronted and unimpeached. Further, we also take note of that the dead body of the deceased Almas was found in the house of accused Abdul Aziz, and Abdul Aziz was sitting in the same room where the dead body was found. From that point of view also, we are of the view that Section 106 of the Evidence Act would be applicable in respect of accused Abdul Aziz to explain as to how the dead body was found in his house. Para 12. A stand has been taken by Mr. M.A. Sheikh, learned counsel for the respondent accused persons that the evidence of PW1 Muhammad Basaruddin in cross provides that the accused Abdul Aziz had told him that the deceased Almas had entered his house upon being injured by someone outside and after entering he had died. But again, the said statement of PW1 in cross is not the evidence of PW1, but it is merely as to what was told to him by the accused Abdul Aziz. Accordingly, in the absence of any such explanation by the accused Jasmat, Mukhtar, and Ziaur, as regards the last seen theory, and in the absence of any explanation by the accused Abdul Aziz, under Section 106 of the Evidence Act, we are of the view that the instant case, the evidence on record is short of being adequate to arrive at any view as to what had happened, let alone forming two views, out of which one is in favor of the accused and one in favor of the prosecution. So, as regards the submission made by learned friend that there are two views, that was negated, my lord. In view of the inadequacy,
Basically, what the High Court has said here is that no view can be made. Forget about two views.
yes, my lord. And Section 106 of the Evidence Act, the other side was given the chance to explain as regards the 106 of the evidence sex because the dead body was found inside the house of Abdul Aziz.
It said that it could do it,
Yes.
but if it doesn't do it,
May I?
if it
May.
did not do it, then what happens?
Lordship, may I take your lordship? Lordship. In view of the inadequacy of the evidence, we are of the view that the matter requests to be remanded back to the taking further evidence so as to make out the circumstances which resulted in the death of the deceased complaint. Accordingly, we remand the matter back to the learned trial court for taking further evidence, and doing so, the learned court shall give adequate opportunity to the accused Jasmat, Mukhtar and Ziaur to render their evidence for discharging their burden under the last seen theory, and also to the accused Abdul Aziz to explain as to how the dead body of the deceased was found in his house. In doing so, the learned court shall also give an opportunity to both the sides to cross-examine any of the witnesses that have already been examined, and also to bring further witnesses for their examination in chief, as well as their cross-examination. And for the purpose of parties may bring witnesses they would like to bring, provided otherwise admissible. Then last part is important, madam. Upon conclusion of the evidence, further opportunity be given to the accused person to make their stand under 313 CRPC. And upon the evidence on record being complete, the learned trial court shall pass a fresh order by giving a consideration of the whole of the evidence, including the evidence already on record. The next line is important, my lord. The judgment and order to be passed by the learned trial court shall take precedence and prevail over the earlier judgment and order dated 28/9/15 in sessions case number 207/2011, passed by the learned edition session. So, my lord, as my learned friend is submitting, my lord, learned senior friend was referring to section 362, whether it would be a review of the earlier order. My respectful submission that it is not, because by honorable court in the earlier appeal has directed to take an independent view of the matter to taking into account the entire evidence on record. It's not the review of the earlier order, because the earlier judge is different, the second judge is different, and your lordship, the next judge who has been taken the lordship trial lordship, whereby he was directed to take evidence or lordship, it's not the review of the earlier order. So section 362 will not be applicable.
Madam, let me ask you a simple.
My lord.
Was there any additional evidence adduced?
There was not. But as my learned friend submitted, there was no 313,
No,
but
no,
it was recorded.
Madam.
They could not bring it anything on record to lordship substantiate their claim.
Madam, I know that it's your duty
My lord,
to make submissions.
my lord.
But it is also your duty to hear us. Let us also,
Oh,
yes, please hear.
She will not take it otherwise, lordship.
No, but please, you've got to hear us also.
My lord.
You see, the simple thing is this, that if the division bench
My lord.
was of the view that the evidence in itself was enough to convict the appellants herein, it could have convicted.
My lord.
But it found that there was not enough evidence to come to any view.
Lordship
Correct?
is very much correct.
So that's why the court said that the trial court can take further evidence
Yes.
of both sides.
My lord.
And they will also explain regarding 106. Now, what it meant was that whatever little it had at the time of appeal, that was not sufficient to convict.
Yes.
Now, why should it suddenly become sufficient to convict when there's no further additional evidence in the trial court?
Lordship,
Was 313 also given?
but nothing.
No. So
Yes, 313, yes, recorded. Yesterday I've gone to the records.
it was given.
Yes, fine.
No, madam, but what I'm saying is, even if supposing 313 was given or not given, the question is the evidence was still the same.
Evidence was still the same, but judge was not still the same.
How-
Evidence,
And how can a judge be the same, my lord?
lordship
This is-
my lord, your lordship will take into account the entire evidence on record. I have nothing to say. then your lordship will come to a conclusion. But this time, the second time, one person is acquitted, two persons are convicted. Lordship, because the learned trial judge has taken entire evidence on record, apply his mind and then come to a conclusion. Now your lordship will justify from the evidence on record whether he was correct or not. As
We are trying.
my lord,
That was granted back
my lord,
for further evidence.
yes,
And later further together that fresh consideration.
yes,
There is no further evidence.
no further evidence has come.
They
Already taken,
already have said that no beef is possible. That is where the problem lies.
lordship now, lordship, my respectful submission is that lordship will take, whatever lordship passes, lordship, it's up to your lordship, but my lord will take up the entire evidence on record, but there are other circumstances which I can bring it to your lordship. Lasting theory, 106 of the Evidence Act, then the conduct of the accused person, your lordship will give a fresh hearing for the appropriate order.
You see, madam, we know the power that we have, that we don't have to tell us. But what we are basically finding is that the evidence, this has said this is the evidence. There was evidence adduced. The trial court acquitted all of them. Correct?
Yes,
It went, the informant filed an appeal before the High Court. High Court came to a finding that the trial court acquitted the appellants due to two grounds, due to the decision made by the Supreme Court that when two views are possible, the view that is favorable to the accused should be applied.
my lord.
However, the High Court said, in fact, their two views could not have been made because no view could have been arrived at
Yes.
on the basis of the evidence. Which
That's
is
correct, yes.
Accordingly, it remanded the matter back so that further evidence could be taken so that the court could come to a finding either this way or that way, or it will come to two views, either way.
My lord.
Now, when it came back to the trial court, no further evidence was adduced by any of the party. Correct? No further,
So, no, yes.
no further
But
evidence was
313
adduced.
is given?
313 maybe, but that is
Okay.
not, you see, the
It's
313,
not a evidence, my lord, yes.
313, the evidence remained the same.
My lord.
Evidence never
remains
changed.
Same.
Evidence remained the same. Now, how can the trial court convict these appellants?
Lordship, because a handle has been given by the appellate court.
Huh?
This appellate court has given a handle to him. Last motion. The judgment and order to be passed by the learned.
I think we have heard you. That is your only.
Lordship, my submissions be recorded. Lordship, because take precedence over and prevail over the earlier judgment.
No,
Lordship, that handle, Lordship, can you have a look, my lord?
no,
Last
wait.
lines.
Pass a phrase,
Yes, my lord.
the evidence, including the evidence already.
Yes, my lord, so entire evidence is taken into account and learned trial judge.
You've got a avenue to the Supreme Court. You please avail of that. We
Submissions be recorded, my lord. That is
Very
my.
I know.
That's a.
No, that's on that point. Otherwise, because it's a par incuriam judgment, my lordship knows it. That judgment is par incuriam. It can't be, my lord.
Anyway, I no need to go into it. It's clear. Right. Item character. The learned additional PP submits that there is no infirmity with the impugned judgment. An order dated 5/6/2025 in convicting the two appellants while acquitting the third court case, even though no additional evidence was adduced by the prosecution or the defense on the case being remanded back to the learned trial court for a fresh consideration. he submits that the judgment of this court on 24/7/2019, passed in criminal appeal number 17 of 2015, provided the learned trial court to come to a different finding on facts, even though no additional evidence was recorded by the party. Inasmuch as examination of the appellant was done under section 313 CRPC.
No, I'm not.
That is what you said.
I'm not on that.
Well,
I am on the point that the learned trial judge has taken into account the entire evidence and record of fresh.
Okay,
And
okay.
because the handle has been given by the appellate
But
court.
even though you part that, you just say that he submits that the entire evidence that had been recorded in the first round of litigation could be considered afresh by the learned trial court and could come to a different finding in view of the decision of this court in Criminal Appeal 17 of 2000. Correct? That's what you.
Lordship, that may be quoted, that line, third line of that may be quoted. The judgment and order to be passed by the learned trial court shall precedence.
I have quoted all the paragraphs in this.
Yes, even I'm relying on the last paragraph.
Okay, okay.
Fine.
We'll put it out. It's already here, para 14, I've already recorded here. It's here, for everyone. Next. She accordingly submits that as there is no, she accordingly submits that as the learned trial court has only followed the dicta, DIKTAT of this court in Criminal Appeal 17 of 2015. There is no review of the judgment and order dated 24, no, the judgment and order dated judgment and order dated 28/9/2015, passed by the learned trial in Sessions case number 2007 of 2011. We have heard the learned counsel for the court. A perusal of paragraph 11 to 14 of the judgment and order dated 24/7/2019, passed in Criminal Appeal number 17 of 2016, clearly shows that this court was of the view that on the basis of the evidence adduced by the learned trial court, no view could have been made by the learned trial court with regard to whether no view could have been taken by learned trial court with regard to whether the evidence favored the accused or the prosecutor. It was on that reasoning that this court had directed the learned trial court to consider the matter afresh after additional evidence was adduced by the prosecution and the defense. However, as can be seen from the record, no further evidence was adduced by the prosecution or the defense. Keeping the above fact in view, we are of the view that there was no basis for the learned trial court to have suddenly convicted the appellant when it had acquitted the appellant in the first round of litigation. The evidence being the same in both rounds of litigation, two different views could not have been conjured up on the basis of the same set of facts. In view of the above reason, we do not find, we are of the view that the basis for the learned trial court is convicting the appellant under section 147, is it 147/302 IPC has not been made up. The reasoning of the learned trial court is perverse and is not in consonance with the directions, our observations and findings of this court in the judgment dated 24/7/2019, passed in criminal appeal number 17 of 2000. According for the reasons stated above, we set aside the impugned judgment in order dated 5/6/24, passed by the learned session judge Barkita session order number 2007 or 207 of 2005. The sentence inflicted upon the appellant was consequent set aside. The appellants are acquitted of the charge under section 147/302 IPC. The appellant should accordingly released from judicial custody immediately.
One appellant, minor. Release. Just not minor.
Why the other one? What happened to him?
No, he's already been minor
On bail. And judicial custody. I guess it's okay, two of them, how does it matter? If not released earlier, if not released on bail earlier. Huh? Return the what is what?
Obliged. Highly obliged.
Keep your.
11. Release or return. Obliged.
Okay, these are the fact based instead of evidence.